In this lesson, what we're going to do is talk about the role of the Supreme Court, specifically in its ability to scrutinize the other branches of government, specifically the legislature in the form of Parliament, and then also the executive. And we're going to begin by talking about introducing the structure and the basic history of the UK Supreme Court. This is the only lesson we're going to do on the Supreme Court, so it's important that we understand in its most basic form the roles that the Supreme Court has, where the Supreme Court came from, its basic history, and where it was before it ended up in the place that it is now. And then we're going to talk about the impact that it has on government, and we're going to use a couple of examples to show the kind of impact that the Supreme Court can have on government. So let's talk about the UK Supreme Court. The new Labour government under Tony Blair passed the Constitutional Reform Act in 2005. Now, this is the significant starting point for our understanding of the Supreme Court, because it was the Constitutional Reform Act of 2005 that established the UK Supreme Court. Now, there is a common misconception that is had that the Supreme Court was created out of this Constitutional Reform Act, and that it was, and that there wasn't any kind of court that existed before then. This is actually not true. All the Constitutional Reform Act did was move the already existing law lords, the people who existed and sat in the House of Lords, to their own separate building. That's all they did. The idea of the Supreme Court and the functionality of the Supreme Court existed in the House of Lords. They were the law lords, and they had delivered lots of judgments on numerous different cases over the years, previously before the establishment of the Supreme Court. And the effective role of the law lords is very, very similar to that of the Supreme Court. So it's not like the new Labour government created the Supreme Court and created all the judges and created this new judicial institution. All it did was move the existing justices to a separate institution, this being obviously the UK Supreme Court. And what it did was, in doing so, established a very significant step in the establishment of the separation of powers between the legislature and the judiciary. It seemed to be the case that it wasn't particularly helpful to have the law lords sitting in the House of Lords judging and effectively adjudicating over legislation that was passed through that same institution. A certain amount of separation ought to have been in place, and that's what the Constitutional Reform Act did. It also did a number of things. It changed the role of the Lord Chancellor and therefore separated powers even more in that regard. But that's an example here of how we get to the position we're in, where we have the UK Supreme Court. It became a physically and institutionally separate body that was separate from Parliament, and in doing so it signified a true separation of powers between these two institutions. Now, in terms of the structure of the court, it comprises of 12 justices. To be eligible to be one of these members of the Supreme Court, you have to have served as a senior judge for at least 2 years, or you would have to have served as a solicitor or a barrister. Mostly a barrister. Mostly barristers are the ones that get picked to the Supreme Court, for up to 15 years. Now, it is the case that, for the most part, the justices of the Supreme Court are taken from the pool of the higher senior judiciary. It's often quite rare for there to be barristers that make their way onto the Supreme Court. However, it's not something that has never happened. For example, the former Supreme Court Justice Lord Sumption was, for the most part, a barrister and a practicing lawyer before becoming a member of the Supreme Court. So he was, I believe, the first person to become a Supreme Court Justice from the role of being a barrister straight into the Supreme Court, rather than spending 2 years as a senior judge. So this is how we get onto the Supreme Court. But what does the Supreme Court actually do? Well, the Supreme Court is the final court of appeal in the UK for both civil cases as well as criminal cases. Now, when we say it is a court of appeal for criminal cases, this is not to suggest that there are any kind of jury trials that take place on the Supreme Court, because the Supreme Court has one main purpose, and that is to hear appeals relating to points of law. So If there is a criminal case, if there is a criminal trial that takes place, the jury, the criminal trial may have taken place at a jury level in the first instance, but when it goes through a court of appeal and then maybe up to the Supreme Court, the issues that are being finalised are issues relating to points of law within the case, not necessarily relating to the facts of the case that are decided by a jury. And so that's what the Supreme Court exists to do, to hear appeals related to points of law. But these points of law have to be not just necessarily minor and insignificant to the wider public points of law, but they're generally points of law that are of national importance, and they are therefore important to the general public as a whole. Now, this isn't to say that there are no Supreme Court cases that don't deal with some quite niche, esoteric areas of the law. That's the case, that is true. But for the most part, they have general application to quite broader scopes within the law. And so that's why the Supreme Court exists. And because they have a lot of national, quite general, wider public points of law that they are dealing with, they're often dealing with cases relating to human rights issues. And that's because human rights and human rights law effectively is a body of law and an understanding that deals with the relationship between the state and the people who live in the state. And therefore, the Supreme Court hears quite a lot of cases relating to the European Convention on Human Rights and the application of the European Convention on Human Rights in the UK, which is through the Human Rights Act. And this is, we've already discussed this in previous lessons. You don't necessarily need to know this for A-level in any great detail, but the Human Rights Act effectively incorporates the ECHR into UK law. Before the passage of the Human Rights Act in 1998, if you had a human rights claim that you wanted to make to the by reference to the European Convention on Human Rights, you would have to go to the European Court of Human Rights, which was in Strasbourg. And so what the Human Rights Act did was incorporate these principles to the point where we can actually talk about these principles in UK law, and we can actually have the Supreme Court adjudicate on issues relating to the ECHR. This isn't to say that you still can't appeal to the court in Strasbourg. You can still do so, but for the most part, the UK Supreme Court deals with these issues and is often the highest point of law that we find. So let's continue to talk about the role of the Supreme Court in relation to the impact that it has on government policy. So the Supreme Court acts as a significant check on both the government and on Parliament. It should be noted that it does act as a check on Parliament, but not in the same kind of way as it does on government. Because while Parliament is ultimately sovereign, Parliament can do whatever it wants in regards to legislation. It could even repeal the Supreme Court if it wanted to, seeing as the Supreme Court exists as a byproduct of the Constitutional Reform Act. Even though all this is the case, the Supreme Court can look to see if they're acting within the legislation that they themselves passed. So if we think, for example, the human rights cases that we've looked at, if we think about it, the Human Rights Act is passed by Parliament, and there is a declaration that needs to be presented under any piece of legislation to make it clear that it is the piece of legislation that is being passed is compatible with the Human Rights Act. That's something that is very clear. And so even though Parliament could easily, if they wanted to, repeal the Human Rights Act, repeal the Supreme Court, etc., etc., from a legal perspective, there is nothing illegal in that regard. But politically, they obviously would not do such a thing because, or at least there have been talks of repealing the Human Rights Act, so I won't put it past them. But at least politically, it's a lot more politically contentious for Parliament to repeal the Human Rights Act. So therefore, the Human Rights Act is something that Parliament seeks to follow and seeks to make sure that all their legislation is compatible with it. And that gives the Supreme Court a certain amount of power with this regard, because they can therefore go into cases, look at cases of judicial review, look to see how Parliament is acting, and say that, hey, this piece of legislation that you have passed is actually in violation of the Human Rights Act. Now, the Supreme Court, unlike the US Supreme Court, cannot strike down that legislation, but what it does is issue what we call a declaration of incompatibility. It states that this piece of legislation is incompatible with the Human Rights Act that you have passed. So two things can happen. Either you can keep this piece of legislation that you've passed and repeal the Human Rights Act, or you can repeal this piece of legislation, or at least reform this piece of legislation so it is no longer incompatible with the Act. Or, I mean, the third alternative is just to keep them both and just to exist in a world where they are incompatible. That sometimes happens. But for the most part, Parliament wants to be seen to be following the Human Rights Act and to be following the general principles of law that are been presented by the Supreme Court. So Parliament would, and has in cases, repealed legislation because the Supreme Court has said that it is incompatible with the Human Rights Act. So that's an example of the Supreme Court being quite a significant check over Parliament, despite the fact that Parliament is ultimately sovereign and can do whatever it wants. But when it comes to the government, the Supreme Court is an even further check over, because the government isn't sovereign. The government is the executive branch, and so it is not sovereign just like Parliament. It is different. Even though we have a fusion of powers, the government exists separately to Parliament. So what we have as an example of the government being checked is the representation that we see in the Miller cases. Now, there are two Miller cases. We're going to discuss one of them here, but a second one I'd like you to research yourself. It is arguably a more significant one, but there's a little bit of contention on that. And we'll talk about the first of the Miller cases, which is Aaron, Secretary of State for exiting the European Union. Now, ultimately, the facts of this case and the main question of this case was whether or not the government could enact Article 50. Article 50 was the provision within EU law that allows for and begins the process of withdrawal from the European Union. The question was, can we pass Article 50? Can the government do that without putting it to a vote in Parliament? Could they just unilaterally enact Article 50? Now, one argument was that they could, because they had reference to the fact that they had the referendum, the EU referendum in 2016, and that made it clear that they had the mandate to pass Article 50 without requiring a further mandate by Parliament to pass it as well. But we know that referenda are not binding onto Parliament and are not binding in law, so it becomes a little bit more complicated. The government argued that they did not need express approval by Parliament to pass Article 50. However, the Supreme Court disagreed, and they disagreed for a very important reason. They said that, in disagreeing, that Parliament must be allowed to vote on the enactment of Article 50. And the reason for this was because Article 50 would represent a significant change in the law, because you are exiting the European Union, and seeing as European Union law represents quite a large body of the broader law in the UK, what you're doing by enacting Article 50 is making a significant change in the law. And since Parliament is the only institution that is allowed to change the law and make any changes to the law, as per the principle of parliamentary sovereignty, if you want to make a significant change in the law, Parliament has to be consulted. That's the basic argument that is made in this case. And continuing, we do sometimes have examples where, even though the Supreme Court, the UK Supreme Court, represents a significant check over the government action, the government can sometimes just choose to ignore the Supreme Court. Because don't forget, the government also has quite significant control over Parliament if they have a large enough majority. And if they do so, you effectively have a situation where you're trying to argue against parliamentary sovereignty, and that's where the Supreme Court doesn't have any power, effectively. And an example of this can be seen in 2005, where the court ruled that a ban on the right of prisoners to vote was a violation of the European Convention on Human Rights. It still is a violation of the ECHR. It is a violation of human rights to not allow prisoners to vote, or at least to have a general overall ban on any prisoner's right to vote. It wouldn't necessarily be a human rights violation to suggest that certain prisoners wouldn't be allowed to vote, but to suggest that because you are a prisoner, by reference to that aspect of your personality, that therefore means you cannot vote. That's a violation of human rights. And you'll notice that this is a ruling that took place in 2005 before the Supreme Court was ultimately established, which was in 2009. So this is a decision that was handed down by the Law Lords in the House of Lords. But this is still a Supreme Court ruling, technically. It's not called a Supreme Court ruling because it was in the House of Lords, but the same justices that are in the House of Lords are the same justices that ended up in the Supreme Court, or at least a few of them were. And so therefore we have a situation where we're showing very clearly that all that happened with the Constitutional Reform Act was the movement of these people from Parliament to their own institution. So they made this argument in 2005. They said it was a violation of human rights and in violation and in contravention of the European Convention of Human Rights. However, it ultimately led to nothing because Parliament did not change the law and the government refused to change the law as well. So this is an example of a significant limitation, a significant weakness of the Supreme Court in regards to being able to provide a significant check over the other institutions of government. The executive and the legislature, because of the principle of parliamentary sovereignty, means that if Parliament has the desire to not want to change the law, or to change the law, or whatever it is that they want to do, that's their right as per the principle of parliamentary sovereignty.